All rise. The Covenant Courtroom is now in session.
The Covenant Courtroom. Imagine two megacorporations merging. The old contracts are shredded, the old debts are wiped out, and a brand new entity is born.
Right. It is a complete corporate reset, governed by entirely new bylaws.
Exactly. But compare that to a marriage. If a marriage hits an absolute crisis, you don't form a new corporate entity. You renew the vows.
Yes, that is a profound procedural distinction, because if we treat the biblical text as an actual jurisdiction, the data proves we have to recognize something crucial. A divine marriage contract operates under a fundamentally different legal mandate than a corporate bankruptcy.
And that is exactly the dispute we are adjudicating today. We are examining the source code of the biblical text, not as a collection of moral stories, but as a binding legal contract.
So does the new covenant represent a legal change in jurisdiction to a brand new entity?
Or conversely, is it a strict, legally mandated vow renewal for the original parties, namely the reunified two houses of Israel?
Right. I am representing the plaintiff in this proceeding, the traditional or Protestant perspective. The forensic evidence strongly demonstrates that the status quo has permanently shifted. The historical record proves that the northern house of Israel was issued a legal bill of divorce, which is recorded in Jeremiah 3.8.
Consequently, the establishment of the new covenant under the Messiah represents a complete change in jurisdiction. The old legal code was fulfilled and dissolved. This granted the Creator the absolute legal right to form a new unified entity built on grace, superseding the strict regulations of the original Penal Code.
And I represent the defense, operating from the Covenant Courtroom position. I submit to the court that the plaintiff's position represents a fundamental breach of contract. To adjudicate this properly, we must utilize the 13-point Scripture Master Charter. This charter serves as our supreme legal precedent.
Let me jump in right there. You mentioned the 13-point Scripture Master Charter. For those observing these proceedings, what exactly does that framework dictate for this specific case?
Well, the Master Charter is essentially the foundational constitutional law of the text. Under Rule 1 of that charter, we find the principle of ontological immutability.
Meaning his nature cannot change.
Exactly. The data proves the Creator cannot change his fundamental nature or violate his own established legal standards. If the Creator abandoned the southern house of Judah to marry a completely new external entity, he directly violates his own triad of conjugal rights found in Exodus 21:10.
Ah, I see the angle.
And he is legally guilty of treachery according to Malachi 2:14. The forensic evidence dictates that the Creator is legally incapable of perjury. Therefore, replacing the original contract constitutes a jurisdictional impossibility. The new covenant is legally categorized as a vow renewal, not a replacement.
I understand the premise of ontological immutability, but the defense's claim of a jurisdictional impossibility ignores a deliberate exit strategy written directly into the source code. Let's enter Exhibit A.
Let us see it.
This is the ultimate smoking gun for my side of the aisle, Romans 7:4. The text here is explicitly clear. It states that believers are, quote, dead to the law by the body of Christ, that ye should be married to another.
Right.
The legal parameters demonstrate this is a calculated, authorized shift in jurisdiction. The death of the husband nullified the old marriage contract. It freed him from the limitations of the previous arrangement. This allowed him to legally marry a brand new, universal entity completely unbound by the Sinai Covenant.
I reject that interpretation entirely. Upon cross-examination, Exhibit A actually dismantles the plaintiff's claim when we apply querium logic.
Wait, hold on. Before we look at the mechanics of Romans 7, what exactly is querium logic? Break that down for the record.
It is a simple legal reality. You cannot take a fish out of an aquarium it was never swimming in. You cannot be released from a jurisdiction you were never under.
Oh, meaning the Gentiles.
Precisely. Pagan Gentiles were never under the Sinai marriage law. Therefore, they have zero legal requirement for the testator's death to release them from it. To claim a purely Gentile entity is suddenly released from the Sinai Penal Code is a jurisdictional impossibility.
But the text explicitly says they are, quote, married to another. That clearly signifies a new party stepping into the agreement.
The linguistic data proves otherwise. When we examine the original language as forensic evidence, the Greek word used for another in Romans 7.4 is heteros. Heteros means another of a different legal status.
As opposed to what?
As opposed to allos, which means another of the exact same kind. The heteros here is explicitly identified in the text as the resurrected Messiah. It is not a new bride.
Interesting.
The husband who died in the flesh was the first legal administration. The resurrected husband is the heteros, the new legal administration.
Even if heteros refers to the resurrected husband, why was a death required at all? If not to dissolve the contract entirely and start fresh, what is the legal purpose of the death?
To answer that, we must submit Deuteronomy 24.1 to 4 to the docket.
Okay, let's actually look at Deuteronomy 24. That law specifically states that if a man divorces his wife and she becomes defiled by another, he cannot legally remarry her. It is strictly forbidden.
Yes, it is.
So if the Creator divorced the northern house of Israel, which Jeremiah 3 says he did, he is legally trapped by his own law. He cannot remarry her.
Exactly. The Creator is bound by his own legislation. The northern house of Israel was divorced and scattered among the nations. She was defiled.
So the death was the loophole.
The testator's death was the only legal loophole available to bypass that remarriage restriction in Deuteronomy 24. The death of the husband does not abandon the original contract. It is the precise legal mechanism required to close out the penalty, allowing him to reclaim the divorced northern house as a resurrected entity.
So it is just a restorative mechanism.
Correct. It was not an excuse to abandon the southern house of Judah, nor a pass to marry a brand new entity. It was the legal requirement to save his original bride without committing perjury.
I see why you structure it that way. But even if we accept that the death of the husband was a loophole to reclaim the northern house, the biological and agricultural evidence surrounding the covenant tells a very different story. Let's enter Exhibit B, Romans 11.
The olive tree.
Yes. Here we find the explicit biological and legal precedents of the grafting of branches. The text identifies wild olive branches being grafted into the cultivated tree. The parameters demonstrate that these are foreign, non-lineal entities brought in to replace the broken natural branches.
But they are not foreign.
Well, they fundamentally alter the genetic makeup of the covenant. The status quo of the original tree is permanently disrupted by a new jurisdiction of wild branches taking precedence.
The plaintiff's assertion violates Rule 7 of the Master Charter, Agricultural Realism. We must submit biological evidence via the law of kind, established in Genesis 1:11-12.
Which states everything produces after its own kind.
Right. The data dictates that a seed must produce after its own kind. If you talk to an orchardist, they will tell you that you cannot simply tape a pine branch to an olive tree and expect it to grow. The vascular systems have to match.
Okay, I follow the biology.
You cannot graft a completely foreign, non-Israelite species into the Commonwealth of Israel and expect it to survive, let alone produce cultivated olive fruit.
So if they aren't a foreign species, how do you forensically identify the wild olive branches?
The wild olive branches are forensically identified as the dispersed genetic descendants of the northern house, Ephraim. They were scattered among the nations, wilded by generations of dispersion and pagan practices.
But they are still olives.
Yes, biologically and legally, they remain olives. They are the exact same species, just uncultivated by the law.
But these wild branches produce an incredible yield. They often outpace the original branches in the narrative. Does the legal logic not dictate that their superior yield justifies their replacement of the original failing structure?
The biological data dictates exactly the opposite. The superior yield of the grafted branch is scientifically classified as hybrid vigor.
Hybrid vigor?
Yes, a wild branch possesses vigorous, chaotic energy, but it absolutely cannot produce cultivated fruit on its own. It requires the established nutrient system of the cultivated root.
So it is dependent on the original structure.
Completely. Romans 11 explicitly commands the grafted branches not to boast against the root, stating, "Thou bearest not the root, but the root thee." The productivity of the returning northern house is hybrid vigor, which proves the original root remains the unyielding status quo.
The root being the covenants and patriarchs.
Guarded by the southern house of Judah, yes. If the root dies, the graft dies. Claiming the wild branches replace the tree is a biological and legal absurdity.
You are arguing that biology and lineage are rigid, that a wild olive branch is just a dispersed Israelite. But if we look at the New Testament's broader social teachings, that rigid lineage seems to get intentionally erased.
Erased? I strongly disagree.
Well, we will move to the sociological evidence which provides a definitive deletion clause for these rigid categories of lineage. I submit the parable of the prodigal son alongside Galatians 3:28, which states there is neither Jew nor Greek. This evidence proves that lineage no longer matters. The parable of the prodigal son demonstrates the inclusion of the younger rebellious son, establishing an entirely new household dynamic, one that is completely unbound by the old laws of inheritance.
The defense rejects this deletion clause as evidence tampering. Let us examine the linguistic data regarding the word new.
Okay, let's look at the Hebrew.
The Hebrew word shadash does not mean something created out of nothing. It means to repair, renew, or restore. We enter Exhibit C, Jeremiah 31:31.
The actual declaration of the new covenant.
Yes, the text proves the new or shadash contract is filed strictly with two parties, the house of Israel and the house of Judah. There is no third-party Gentile entity included in the legal filing.
But how does the defense reconcile the prodigal son? The younger son leaves the jurisdiction entirely. He goes to a foreign land, lives like a Gentile, and wastes his inheritance.
He does.
And when he returns, the father throws a massive feast, completely bypassing the elder son's grievances. Does that not establish a new universal household where the old rules of inheritance are thrown out the window?
Not at all. The parable of the prodigal son is a flawless forensic case study of the two houses. If we analyze the first-century cultural context, the elder son who remains in the house, observes the laws, and guards the estate represents the southern house, Judah.
And the younger son?
The younger son who demands his inheritance, leaves the jurisdiction, and squanders it among the swine represents the northern house, Ephraim. Living among the swine is a direct cultural identifier for the Gentiles. He became legally dead to the family.
Fulfilling the prophecy in Hosea of becoming Lo Ami.
Exactly, Lo Ami, which translates to not my people.
But his return changes the rules. The elder son is furious because the returning son is treated with grace, not the strict penal code of the law.
And look at how the father legally addresses the elder son's jealousy. He states definitively, "Son, thou art ever with me, and all that I have is thine."
Retaining his legal standing.
Yes, the evidence proves the inheritance and the legal standing of the southern house was never revoked. The estate still belongs to the established laws of the household. Furthermore, regarding the plaintiff's use of Galatians 3:28, neither Jew nor Greek, you cannot sever verse 28 from verse 29.
Verse 29 being the condition of belonging to Christ?
Exactly. Galatians 3:29 dictates that if you belong to the Messiah, you are Abraham's Zerah, his literal, legal seed, and heirs according to the promise.
Meaning you have to be legally adopted?
Yes, you cannot inherit the land and the kingdom unless you are legally adopted into the specific family of Israel. The returning entities must become Abraham's seed. The lineage is not deleted, it is the absolute prerequisite for the inheritance. If there is a deletion, it is the deletion of the barrier to entry, not the deletion of the household's identity.
The defense argues for strict inheritance in lineage, but we have to look at the culmination of the story. The final execution of the covenant undeniably includes all nations.
Well, let's examine that terminology.
The data points to the fullness of the nations as the ultimate fulfillment of the contract. The final judgment metric is universal. It transcends the borders of Israel and includes a completely non-lineal jurisdiction. The entire globe is brought into the fold.
So how do you account for a global population if this is strictly a national vow renewal?
The phrase fullness of the nations, or in Hebrew melo hagoyim, is precisely where the plaintiff's case collapses. We must submit the origin of that specific legal phrase into evidence.
Where does it originate?
It comes from Genesis 48:19. Jacob is prophesying over Ephraim, the head of the northern house, and he decrees that Ephraim's seed shall become the melo hagoyim, the fullness of the nations.
So you are saying the phrase does not actually mean every nation on earth.
Correct. The nations being brought in are the dispersed seed of the northern house who had assimilated into the Gentiles over centuries of exile. It is a massive, global genetic reclamation project, not a universal nullification of borders.
A reclamation project.
Yes. And for the final execution of the covenant, we submit the architectural blueprints of the New Jerusalem, found in Revelation 21:12, as absolute final forensic proof.
The blueprints of the city? How does architecture prove a jurisdictional mandate?
Precisely because architecture reflects ownership and jurisdiction. If the kingdom shifted to a new, universal non-lineal jurisdiction of grace that replaced the original parties, the architecture of the eternal capital city must reflect that change in ownership.
Right, there would be new designations.
Exactly. The data proves the city has 12 gates. On those 12 gates are written only the names of the 12 tribes of the children of Israel. There is no Gentile gate. There is no Reformation gate.
It is exclusively tribal.
To enter the city, one must legally belong to one of the tribes of the Commonwealth of Israel. Kingdom centrality is maintained through eternity. The original law remains the standard.
That is a fascinating architectural point. If the kingdom is entirely universal and non-linear now, you would expect a Gentile gate, but I have to push back on that.
Go ahead.
Even if the gates retain the names of the tribes, doesn't the sheer scale of the fullness of the nations imply that those tribal names have simply become symbolic categories for a global population? At some point, the sheer volume of the wild branches outgrows the original tree to the point where the tree's identity is fundamentally transformed.
Transformed in scale, yes, but not transformed in legal jurisdiction. The gates are literal checkpoints. If you arrive at the New Jerusalem and demand entry based on a corporate merger that dissolved the 12 tribes, you will find no legal point of entry.
You're saying the symbols are literal law?
The Creator does not use symbolic architecture to obscure legal reality. The jurisdiction remains inextricably tied to the reunified two houses of Israel. Claiming the Creator abandoned the original contract with Judah to forge a new entity is a fundamental breach of contract and a jurisdictional impossibility.
Well, we have covered immense ground today, and we must synthesize the entirety of the courtroom proceedings. Both sides acknowledge the profound complexity embedded in the source code. To summarize the findings from the plaintiff's perspective, the traditional understanding presents a substantial case that the status quo was irrevocably altered. We looked at Romans 7, which provides an explicit legal mechanism where the death of the testator executed a binding change in jurisdiction. Furthermore, the Galatians lineage clause, declaring there is neither Jew nor Greek, strongly suggests the covenant was opened to a new universal entity, unconstrained by the original rigid contract of Sinai. The argument stands that the old framework was dissolved to make way for a global administration of grace.
And the defense summarizes the findings strictly through the jurisdiction of a 13-point master charter. The parameters prove conclusively that the new covenant is the legally mandated mechanism for the repair and reunification of the two houses.
Relying on the original legislation.
Right. By analyzing the aquarium logic of who is actually bound by the law, the agricultural realism of the wild olive graft needing the cultivated root, and the explicitly tribal gates of the New Jerusalem, the legal parameters dictate one profound reality. The Creator cannot commit perjury. The new covenant is the ultimate vow renewal.
Vow renewals demand rigorous analytical attention. Whether one views a text through the lens of a dissolved corporate merger making way for a new universal entity, or as the unbreakable covenant of a marriage that required a miraculous legal loophole to restore its original parties, the evidence is now before you. The verdict is yours.
What is your verdict?